Hi, and welcome to this week's 5-Minute Masterclass. This week I want to talk to you about care proceedings. We've talked previously about court statements, and we've talked about how your disclosures and your records of disclosures particularly could be used within court proceedings. What we haven't yet looked at are the court proceedings themselves and how they come about. Many of you will know that when a disclosure is made, there are reporting and recording procedures to follow, and they result sometimes in what's called a Section 47 inquiry. Now, they are the basic inquiries that are made by social services around whether or not a child's welfare is at risk of harm. In some circumstances, that inquiry results in a further intervention with the family, which might be on a child in need basis, which is a low-level intervention with social services that involves visits, or it may well be that the concern is such that there has to be a child protection plan, which results from a conference that takes place, an initial child protection conference to start off with, and then they are reviewed on a 6-monthly basis. Now, of those low-level interventions, there's a lot of opportunity for work to be done with families, and a lot of opportunity for other professionals to become involved with families in order to safeguard the welfare of the children. However, if the situation is such that none of those interventions work, then a local authority will look at what else needs to happen in order to safeguard children. Now, that might be that the next step taken is that of a pre-proceedings meeting. And that pre-proceedings meeting is basically an opportunity for the local authority to say to parents, look, this is what needs to happen, and if it doesn't happen, the local authority is going to start care proceedings and will look to remove your child from your care. Now, in some circumstances, the pre-proceedings meeting is all that is needed, and lots of work can be done again. The reality of the child potentially being removed is enough, and the families work together and the child is safeguarded and protected. Other family members can rally round and lots of things can happen at that stage. However, if that still isn't enough, or if there's been an emergency situation which has resulted in an immediate risk of significant harm, perhaps the police have been involved and they've removed the child from the parents or from the carers, then the local authority will take care proceedings. Now, what that means is that the local authority has evidence that there is at least a reasonable risk of significant harm to a child or to children. And the local authority has to demonstrate to the court that there is a reasonable risk of significant harm to the child and that there is evidence of that. And that's where the 26 weeks that gets thrown about in child protection circles comes from. The law now says that when a local authority starts care proceedings, it has 26 weeks from the day the court proceedings starts, the day the application the local authority is making is sent to the court, until the day that a final order is made. Whatever that order is, that has to happen inside 26 weeks. So that's why when you get phone calls or you get emails from local authorities saying, we need a statement, we could really do with your records, and there's always an urgency to it, that is why. So a local authority, first of all, has to demonstrate there's a reasonable risk of significant harm, and it does that by gathering evidence, it does that by assessing, it does that by analysing the evidence it has, and it does that by gathering evidence from third parties such as nurseries, GPs, health visitors, perhaps probation, people like that. Finally, if a local authority is saying actually the risk is so high, we can't allow this child to remain in the care of the parents or the carers, the local authority has to demonstrate that there is an imminent risk of significant harm to a child. And again, your evidence could be crucial here. Your report, your statement, the disclosure that a child has made could be crucial to demonstrating to a judge that there is an imminent risk of significant harm if the child was to remain with their parents or their carers. And finally, at the end of proceedings, a local authority is demonstrating that at the time protective measures were taken, so the time the child came into their care, the time the child became the subject of proceedings, that there was a significant risk of harm posed to that child. So that's a very quick whistle-stop tour through a Section 47 inquiry through to care proceedings. But hopefully it gives you a bit better balance of the information and a bit better idea of where you fit into the jigsaw and why your evidence is needed. So when a local authority asks for it, it's because it needs the evidence to demonstrate that there is a significant, or at least a reasonable risk of significant harm to a child. Until next week, take care.